Hello, I am Stephanie Joy, the attorney at All Things Social Security and Joy Disability Law. Your video is about to start. I just wanted to remind you that if you click the join button below, you can learn more about the memberships offered at a very affordable price that can give you a little more direct attorney answers to your questions. Have a great day and enjoy the video. Good afternoon. Happy Saturday. Okay, I just wanted to let you know about a possible thing that happens at hearings. It's not that unusual. It just happened to me recently. It may be, and if you have a representative or a lawyer, usually it might happen privately between the judge and the lawyer outside of your hearing, meaning it could be before you come into the hearing room, assuming you're doing the MS Teams video hearing, or it could happen while you're in the room, before testimony is going to be taken. Sometimes there's these kind of like preliminary issues to go over. And one of them is, at times, the judge will suggest, have you considered amending your onset date? And this is often a really good sign that the judge has found a disability date, that there was an onset, a point where you met the very tight rules of proving that you're disabled. Generally speaking, and every case is different, if there is reason for potentially amending an onset date, I've already discussed it with my client before the hearing. Usually we have a discussion that week when we do our trial prep or hearing prep for a few hours. So it can be because maybe the medical evidence did not show at the time you alleged you were disabled that you were disabled. Doesn't mean you weren't disabled, but you just don't have the evidence to show that it started then. The evidence, maybe you were following good legal advice and getting some of those diagnostics we talk about, following up on some of those conservative therapies. Various things could have happened. And now suddenly, 3 months later, you actually have in your file the evidence dated 3 months after the date of your alleged onset date, that would support a finding that you meet the strict criteria to prove you're disabled at that time. That's one way it can happen. Another way is that you changed age categories at some point. So let's say you were, 49, and a year later you turned 50. You're now in a different age category, and another rule applies that gives a little bit more of a area in which you can prevail that you could not do on the same evidence at 48. It can be the exact same evidence, but it won't work until you're 50 because this other rule, I'm not going to go into the complications of the grid, one of my favorite areas of Social Security disability law, but sometimes that can be where the judge, where the judge is leading, like with the person be willing to amend their onset date to their 50th birthday, because I'm seeing evidence that I can uphold an award at that date that isn't available at the prior date. So I would say definitely if you did an age change between your alleged onset date and your hearing date, you're going to want to consider it. But you always have to make sure that change of date is before your DLI, date last insured. If you allege your onset date to a date after your date last insured, you won't get SSD. And I don't think the judge is going to try to trick you with that. It could be you have a concurrent claim and it's SSI, SSD, and there's just no way you can prevail on SSD because your DLI occurs and you don't have strong evidence before it occurred. Every case is very specific. Maybe you didn't know that the kind of rigorous follow-up you should have been getting all along, whatever the case may be. So consider amending the onset date to when you know things got really bad, when you're looking through every page of the medical evidence that is in front of the judge. And of course, remember, if you're pro se, you have a pretty hefty obligation to be sending in medical evidence. I mean, the judge will help you, but you don't want to be relying on a very busy judge and those staff that assist the judge, you want to know what's in there and what's not. You can call, if you're unrepresented, you can call the OHO office and find out, what evidence is in there. Sometimes they'll send you a list and you could say, oh, this doctor's missing and this, or they'll send you the CD. They often do the CD so late in the game. It's a shame that you guys don't have access to see all what's in there without having to go through the rigmarole of getting them to send you a copy. But in any event, find out, don't offer it up without a reason. Oftentimes I will mention that it's a possibility in my brief, and I do briefs on all my cases. And the hearing I just had, the judge was overtly expressed gratitude for having a brief. So I do them for judges that don't want them and those that definitely want them, because often I don't know the difference, because it's just my practice to do them. I think it makes us better advocates at hearing the cases drilled into the head and no details are left out because we itemize them all. So we do a little bit, probably more than many practitioners do, but it undoubtedly produces the high results we see. So to us, it's worth it. But by going through that, that's where I put in my amended onset might be a consideration, if it is. It's not every single case. Definitely when there's an age change, it can be something I want to have considered, because you really want to get that win and not necessarily fight over those extra few months of back benefits. I know maybe some lawyers don't want to hear that because, our fee depends on those back benefits, but the ultimate goal is that our client prevails regardless of if it shrinks our fee. It just is. I've had it where I've urged my client to amend and there was going to be no back benefits. And I know it, but that the premier goal has got to be, and the duty of us as practitioners is that our client prevails on their case and gets their benefits going forward. And sometimes, if a judge offers up the possibility of amending, first of all, I confirm with the judge that means she will award if we amend the onset date. If the judge can't do that, then it's a little problematic, because any judge that's offering it should be because they found enough evidence. So I kind of get them on the record about that if they haven't done so themselves. Most of them have done so themselves. They're up and up people. But you want to get it on the record. I propose it in advance. You might not be well versed enough in the practice of your own case to do that, but if the judge does offer that possibility at hearing, and I don't know if they do it with pro se people, because it's explaining the whole repercussions and, well, you're going to shrink your back benefits, but you've definitely won your case, and I'm clearly not finding you disabled on your onset anyway, so you're going to fight a thing. I'm going to deny your onset date. If I'm up and up, I'm going to give you a partially favorable on the onset date that I think I have found, but you refuse to amend your onset to, and you don't have to amend your onset. It's always voluntary. The benefit of not doing it, if you think you would win on appeal, which is, as you know, unlikely, meaning appealing to the appeals council, then maybe you're like, no, I'm going to stick with my alleged onset date, and that's the end of that. And if she denies me or gives me a partially favorable, I'm going to appeal that onset too. Have at it. It's for those of us that have practiced this for decades, we kind of can see when, well, that was a 50, maybe it was like a 30% chance of winning the old onset date, and the judge isn't buying it, but the judge is going, finds it at this later date. Some people are high risky rollers. I'm not one of them. I will discuss with my client the pros and the cons and the weaknesses of that. So sometimes, the judge is giving you a picture of what she has found. And if you want to get an award now, consider amending to the date that she can award you on. And then she can give you the fully favorable on the amended onset date. So it's, it's something to think about. If your goal is to, I'm not so sticky about the date I became disabled, because I realize that takes certain evidence and maybe I didn't have it all then, and take in the later date. You're going to start getting your benefits going forward. It might delay your Medicare. It might not. It depends how many, the whole rules on the Medicare weight. And each case, of course, is fact specific as to dates for that. But just give it a consideration and review it. And particularly, the obvious one is when there's a category age change. Okay. All right, folks. I will talk to you later. Bye.